Thank you, Mr. Chair. I think I'll ask this question of Professor Brzezinski, and it's this: if you're told at the time you're buying an Apple product that you can only have it repaired by Apple, aren't you adequately informed that you will need to go to that one place and indeed may have to pay twice or even three times for something you bought once? What's the justification then if you were fully advised? No one reads that 50-page contract at the beginning, but let's assume by some miracle you did. Then why should the right to repair interfere with that full disclosure?
Thank you so much for the question. So I would begin by pointing out, as you do, that consumers are often not informed about the terms of these sorts of transactions, right? When you're presented with a 10,000-word license agreement, most consumers, and I think rationally, don't engage with those documents. They're designed to be difficult to read and difficult to understand. And so oftentimes consumers are lacking that kind of clear disclosure that I think they need in order to make informed decisions.
Right, but of course, I took that off the table, so could you answer the question, because I just want to know if I want that Apple product badly enough to submit, if you will, to having to pay for it 3 times, then why should we let this so-called right to repair interfere with that agreement?
So I think it is it's important to keep in mind here, right, that not only do we have questions about kind of the adequacy of these sorts of disclosures, but one reason that consumers are engaging in these transactions and buying these products is because of consumer lock-in, right? A consumer who buys one Apple product is far more likely to buy another because those devices communicate with each other, offer sets of features that make it hard for consumers to break out of those ecosystems. I think it's also important that in some cases it's not just an absence of disclosure, but it is affirmatively misleading promises and statements that are being made in the marketplace. So John Deere has a history of saying lots of things.
I'm still not sure that you're answering my question, but what I'm really trying to get at is if the manufacturer of the product makes adequate disclosures and the consumer then agrees to purchase with those disclosures in mind, it would seem to me that the consumer has waived any right to make this a repair argument. But I'm going to move to Mr. Hartline for a minute. And the opponents to repair argue the right to repair law should weaken intellectual property, and I think you mentioned that. A bunch of states have passed these right to repair laws. So have you seen a noticeable decline in intellectual activity as a result of what these states are doing? And it's going to be hard to measure, is it not? But perhaps you have an example.
Well, so there's only 2 states that have passed laws related to electronic devices, and that's New York and Minnesota, and neither of those laws have really gone into effect yet. So we don't know what's going to happen. What I suspect is going to happen is, especially in the Minnesota law, which doesn't have a carve-out for federal IP protection, is that there's going to be litigation over that law based on the idea that it's preempted by federal copyright law and patent law. And the reason is because the Minnesota law tells IP owners that they have to turn over their IP protected things, and federal law says no, you get to keep those to yourself. And if you don't mind, I do want to talk about the idea that people know going in. Like, I bought an iPhone and I didn't read the 10,000-word thing, but it's the point that you're making is, as long as there are adequate disclosures and there's no fraud on the public, then these are not competition issues, and there's just nothing wrong with it.
I want to go back to one of the elements of this discussion I was researching over the weekend, and it was this. The interest I have in knowing where the 30 months comes from and knowing how you measure the value of the idea and then suddenly say we're going to protect it for 30 months. And
I'm sorry, the 30 months in the SMART Act?
Yeah, sure.
I'm not an economist, and that does seem arbitrary. And the term right now for a design patent is 15 years. I don't know how to say what the optimal term is, but I do think it's a bad idea to take away people's design patents so you can let other people make exact copies and then say, oh, that's innovation.
Thank you all for being here. Yield back.